Apologies to Senator Power, because Senator Power, according to our practice committee, should have been brought in first. But Senator Power. Sorry, thank you, Chair. And just want to thank all of our guests for your initial contributions. I suppose I want to start by welcoming the bill, and particularly on commending Minister Burton for being the first minister to bring forward legislation in this area. And I think it's important to acknowledge that, I suppose, maybe before we get into critiquing it. But I am concerned, as Deputy O'Sonnig has outlined, as I know other members will express, about a number of provisions in the bill. And personally, I strongly believe that all trans people should be entitled to legal protection, regardless of their age, their marital status, their civil partnership. And I think that when we are now coming to this legislation at such a late point in comparison to other European countries, we have an opportunity to learn from those experiences and get it right first, and actually start with best practice rather than starting with where other people were maybe 10 or 20 years ago. So I think those are big issues, as Catherine and Andy have so eloquently outlined. Lack of protection for young people has a huge impact, and this committee is responsible both for social protection and for education. And to hear about the obstacles, the day-to-day obstacles that young people have to experience in our schools, and the impact that that must have on their education, I think is something that we can't ignore as a committee, and it certainly is a strong argument for me for adopting the changes that have been proposed by the Ombudsman for Children. But the main area that I want to ask questions about, because I know we have the department at this initial stage today, is about the forced divorce requirement. Because some couples maybe won't, some couples don't survive transition and go their separate ways, but many do stay together. And I have to say that again, other countries have taken a different route, and there have been challenges, court cases, European Court of Human Rights cases, as well, where forced divorce requirements in other countries have been struck down. But I mean, I have two main issues here. One is that, as Tenny have pointed out in some of their correspondence, there's a chance legally that if a couple has survived the process of transition, they're happy to stay together, they want to stay together, there's actually a very good chance that a court might decide that they don't satisfy the criteria for divorce because they couldn't be considered to be totally irreconcilable. These are people who actually want to stay together and keep their family together, so I think that's a risk. But if indeed, divorce does apply and that's not an issue and people are able to get a divorce, I still think it's really problematic to force a family to split up. For the spokesperson, Simonetta Ryan from the department, said that you referred just briefly to the constitutional context as the reason for that requirement. I'd like to have more details on that, because if anything, I think there's a constitutional context for protecting the family. Protection of the family is very strong in the Irish Constitution. Protection of marriage, again, incredibly strong, and I think it could be constitutionally problematic, and I've read very persuasive legal opinion on this, to force a family to break up. You actually have an external group imposing divorce on a family. I think could be very constitutionally problematic. And secondly, I think that it's, as far as I can see, and from the work that's been done by Fergus Ryan in particular, wrote a very good article on this. I think it's also legally unnecessary, because in Irish law in general and family law, the validity of a marriage is based on the status of the people at the time that they entered into it. It's whether you were actually capable at that time of entering into a valid marriage, and I think it's arguable on that basis that it's completely legally unnecessary to go separating people, forcing people to divorce many years later if at the time that they got married they were capable of contracting the marriage. So putting aside the issue of marriage equality that hopefully will be dealt with in the near future, even before any of that is looked at, I think it's actually unnecessary, because the marriage was valid at the time that it was contracted. But I suppose I'd like to finish just by asking if the department would share your legal advice with us, because frankly, I don't think it's good enough just to say that there's a constitutional context. I think we really need to see the meat of this, because all of us as members want to do the right thing, but legally want to make sure that legislation that we pass will stand up to scrutiny in the courts. But we need to have that information as well to be able to judge this issue properly. As I said, contrasting opinions have been put forward by Fergus Ryan, by FLAC. There's a letter there from the Council of Europe Commissioner for Human Rights to Minister Burton in relation to the ECHR context of all of this. I think it is a very big legal issue, and I think for us to discuss it meaningfully as a committee, we should all be working off the same information. So I'd like to make that request to the department in particular. Thank you. Briefly on that, I mean, there's no prohibition on you sharing the AG's advice. I know it's not standard practice, but there's a massive gap between maybe even sharing the full advice with us and giving us a one-line sentence saying that there's a constitutional context that prevents something happening here. Because I've already, as I outlined initially, there is strong legal opinion on the other side as well. This is nothing to do with same-sex marriage, and that marriage. But the validity of a marriage depends on the circumstances that existed at the time. There's a whole load of case law to back that up, and I think that the very least we should get is at least a paper from the department as part of these discussions, setting out the main arguments or the cases that you're referring to, the legal precedent that backs up the arguments, and not just. I think it's difficult for us to evaluate the thought that you put into it if all we're being told is the department is considered a constitutional context. I think we actually need to have a bit more meat than that to be able to do our job. I mean, when the legislation comes before the committee, we'll be thinking through amendments and things like that, and how are we supposed to make an informed judgment on your arguments if we haven't heard them.
Senator Power.
Thanks, and thanks everyone for your presentations and also for the written submissions as well that we read ahead of the meeting. I think between all of you, you've put forward a very strong case, particularly that on the different issues, but especially I think on the fact that the forced divorce provisions not only are legally unnecessary, and I think I read Fergus Ryan's paper ahead of this and we discussed some of that yesterday, Fergus, but the fact that they're probably actually in breach of not only our constitution but also the European Convention of Human Rights as well. And I think the point has been made very well about how they're arguably disproportionate based on the German precedent, which is looking at it not only its constitutional context but also the same European Convention on Human Rights responsibilities as we have. And it was decided in that context on the basis of proportionality. So I think there's been a very strong argument made there. I think to have the Equality Authority flack Fergus Ryan, and from a constitutional point of view, we've the Council of Europe Commissioner on Human Rights wrote to us on that point. The decision of the German Constitutional Court, just from my point of view, makes me even more unhappy about the lack of engagement that we had from the department officials yesterday in relation to that legal issue. Because, I mean, I raised this point, I know the officials are in the gallery, and I appreciate that you're sitting through this discussion. I hope that the department will reflect on that, because I accept the fact that maybe yesterday when we had representatives in from the department, they weren't in a position maybe to engage on this, but I think it's essential, Chair, that we bring the department back again at a later point and engage on this, because yesterday we were simply told that the only legal argument we were given, it was a one-line explanation that there's a constitutional context as to why the forced divorce provisions are there. I think it's quite clear from the testimony that we've had today that there are incredibly strong constitutional arguments that this legislation is completely repugnant, not only to Bunreacht na HÉireann but also to the ECHR as well. And I think that it would be bizarre if we go through 2 days of hearings and we have a consultation process on this legislation and not engage on that legal point and not actually have the department discuss it with us. Frankly, I don't think it's good enough. I think it makes a bit of a mockery of the committee not to engage on an issue so significant. So I'd just like to make that request to the Chair, and we can discuss it later amongst the members to invite the department back to engage on that point. I also think the age point has been made very well. I mean, the suggestion was made yesterday that 16-year-old trans people will be 18 someday, and can they wait till they're 18? Sadly, that's not always the case, because the rate of suicide amongst young trans people is incredibly shocking. A US study found that up to 50% of trans youths will have made at least one suicide attempt by the time they're 18. And that's the context that, again, we're looking at this legislation in. And we heard the really practical day-to-day struggles that people have yesterday with participation in the education system and how impossible that makes some white kids drop out of school because of all of this. So I think the age thing, again, is absolutely crucial in this legislation, because you're talking about incredibly vulnerable young people, and we have an opportunity here to get that right. And what we're being asked to do is very simple. So I think actually the suggestion that was put forward again, and the Deputy Attorney raised it about the temporary sort, gets around some of those issues, because again I agree with the point, if parents agree that this is in the best interest of their children, we might let parents refuse operations, sometimes really important operations of course, if upheld on behalf of their children. We give them that kind of responsibility. If parents agree that their child should be allowed to have their self-identified gender recognised, I think it's crazy that the state would interfere with that. But maybe the temporary sort is a way of getting around that for younger people. So I suppose I'd just like to ask the others if you agree with that suggestion, that maybe from 16 up we should recognise the fact that generally in terms of legal capacity 16 is the age, and I think that should be recognised for the young person being able to make a decision in their own right, but that before that perhaps a temporary sort with the parent's permission is the best way of getting around that, and it deals with the issues that were raised by some of the speakers yesterday about concerns about regret and things like that. I think we all have regrets. If a point was made about marriage and other long-term decisions, negative equity perhaps is a 35-year commitment that people regretted quite soon afterwards. You can't make legislation, in my view, on that basis and the fact that somebody might regret it. Again, the vast majority of people don't. Vast majority of people who transition and have their gender recognised don't, but perhaps the temporary sort might be a way of getting around that in respect of younger teens.